So I taught middle school for 9 years, and while I was there, I always noticed this sign by the copy machine that talked about copyright. Well, it was a copyright notice, and I never really paid much attention to it. I mean, I'd read it, I'd give it a wink when I made copies of the textbook or worksheets, but as a faculty, we never really talked about it. Well, today's the day. Today we're going to talk about copyright. A copyright is essentially the right to copy. Laws about copyrights have been around since 1710 in England, and today copyright law is worldwide. Copyright protection is written in the United States Constitution. Article 1, Section 8 states that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the copyright holder has exclusive rights. As soon as the creative work is captured in a fixed format, that creation is protected by copyright. It's automatic. Examples include literary works, artistic works, music, and in some instances, industrial designs, models, and computer software. As soon as those are created, the copyright takes effect. Now, there are some exceptions. For example, a work created while being an employee of a company, work you create as a teacher or university employee, or work you co-create with somebody else. However, once a creative work has a copyright, which is the moment it's created and in a tangible form, then the copyright holder has the right to control how that work is copied, distributed, performed, displayed, and any adaptations of the work, like making a movie from a book. There are some things that don't have copyrights, like ideas, facts, and data. Copyrights are also different than trademarks and patents. Additionally, copyrights can also expire, but not usually for a very long time. The public domain are creative works that are not subject to copyright. A work can enter the public domain when the copyright expires, the work does not qualify for copyright protection, or the work is dedicated to the public domain before the copyright expires. There are a variety of places to find work on the public domain. It's important to know that public domain is different than publicly available. There are some exceptions and limitations built in the copyright law. Fair use is using a copyrighted work without permission. Some examples of fair use include writing a critique of the work, creating a parody, using the work for news, education, and research. In the United States, federal courts decide fair use using a four-factor test where they consider four things: the purpose and character of the use, for example, is it being used to make money, the nature of the work, the amount of the work used, and the effect of the use on the market. The court weighs all four factors to determine fair use on a case-by-case basis. As a YouTube creator, using a disclaimer in my video claiming fair use doesn't mean the work qualifies as fair use. Only a court can determine that. In a similar vein, while first sale permits the selling of a created work, it does not give me, the owner of the book or CD, the right to copy or publicly perform the work. As a child of the 80s who grew up making mixtapes and mixed CDs and video clips, learning about copyright law was very eye-opening. There's a lot more to learn about copyright law, so feel free to watch and learn and read more using the links in the description below. This video was made using the Creative Commons license. So next time you're at the copy machine, as a professional, ask yourself if you have the right to copy.